I would like to welcome you to AUL's Legal Symposium. Americans United for Life is the legal architects of the pro-life movement. We are accumulating victories, building momentum, and advancing a culture of life in America. And I am Janine Maxson, AUL's Vice President of External Affairs. When we were here last year, I was a little bit discouraged, quite frankly. We had just inaugurated the most pro-abortion president we had ever seen, and we were looking at 40 years of Roe versus Wade. But looking back at this past year, we've seen some incredible victories. Shortly before the march started last year, Time magazine came out with a cover article that said 40 years ago, the pro-abortions won an epic battle in Roe versus Wade, and then at the bottom they said, and they've been losing ever since. And that's really what 2013 has shown us. Just a few weeks ago, the Guttmacher Institute came out with a report, and they were quite upset about it, that in the past 3 years, more pro-life legislation has been enacted than in the entire previous decade. And at Americans United for Life, we were very excited as just this past week, Rolling Stone came out with an article where they said that AUL is responsible for the recent highly successful and under-the-radar strategy related to this pro-life legislation. And the woman who is leading this strategy is our president and CEO, Dr. Charmaine Yost. Dr. Yost began her career in D.C. at the Reagan White House, and she later went on to serve as a senior advisor in the 2008 Mike Huckabee for President campaign. She has testified in the confirmation hearings for Justices Kagan and Sotomayor, and she is a regular political commentator and author who is often quoted by the media and has been profiled in such media as the New York Times and Christian Science Monitor. She received her PhD from the University of Virginia, and she has 5 children with her husband, Jack. Please welcome Dr. Charmaine Yost.
Well, good morning. These are the hardy ones. Tell you, I love this event. I love the March for Life. To me, there's really nothing more inspirational than to see thousands and thousands of pro-lifers who know that there's about 5 to 7 inches of snow about to be dumped on our heads. The federal government is closed. There was nobody on the roads today except pro-lifers coming to band together and to think about where we're headed, what we've accomplished, and what's coming next. Do you know, so that's thank you. Thank you very much for being here. Janine mentioned Rolling Stone, and we've kind of been laughing internally because the headlines talked about the stealth war against abortion. So here you are this morning. We're all being very stealthy as we speak right into the microphone to tell you where we see this battle going. Because really what I'd like to highlight this morning is some things that I think need to be very, very public about how we are addressing the abortion issue and where the pro-life movement is going. Do you know, something that doesn't generally make my introductory comments as people are introducing who I am is a part of my bio that was a brief period in my life, but one of my favorite experiences is that after I served in the Reagan White House, I was trying to figure out where I was going to go next. So I spent some time in England at Oxford University working on ethics and philosophy. And as you know, in the English system, it's different than the way we do it here, and that's one of the reasons I wanted to spend some time there, is they believe in having a tutorial system where you interact with one-on-one with a professor, and he challenges you and questions you very intensely over a particular issue. And so in meeting with my tutor, the first thing that he asked me was, why was I pro-life? And he wanted to challenge me on that. And as I talked about why I was pro-life, he cut me off very dismissively, and he said, I want you to go write a paper on why a woman should have a right to choose. I was a little dismayed and surprised that that's how he wanted to start our relationship, but I went off and I wrote a really, really dreadful paper, which he cut to shreds. And he made me go back and write it again. I think he made me write it again several times before he was satisfied that I had really, really explored my opponent's arguments on this issue. So that's part of what I want us to have as a subtext as we begin this day, is thinking about our arguments and thinking about where we are moving as a movement in talking about abortion and engaging with our opponents who think so dramatically different than we do. Janine mentioned the New York Times looking at our strategy, and honestly, they spent at least 6 months talking to various members of our staff and delving into going through reams and reams of AUL material. And one of my favorite moments from interacting with that reporter is I told her this story about Oxford, and she said, well, in that experience, she says, what did you come away thinking was their most cogent argument? What was the most difficult argument that you find to engage with on the pro-choice side? I stopped and thought for a minute, and I have to honestly tell you that I think that their arguments are not good at all. They're not good at all. I have a hard time identifying one that I think has any intellectual consistency or integrity to it. And that is why you see such a continual dodge in engaging with those who are trying to advance the cause of abortion. They don't want to talk about what is actually going on in this arena, so they continue to come up with different ways of packaging and relaunching their argument. Perfect example. Sometimes people ask me about my social media presence, and I have to respond that I do have 5 children. So you can find me on Twitter, and those of you who are law students here, I hope you'll you'll tweet at me today, hashtag Team Life, hashtag Why We March. You also want to follow Catherine Lopez, who is one of my favorite commentators on Twitter and pretty much anywhere else. So recently I was, in a cab or something, and I was scrolling through my Twitter feed, and something caught my attention. And it was an exchange from a young woman on the other side, and she made the comment, "But the baby doesn't have a choice." "Thanks, sir, I've never heard that one. I renounce my activism. Hand me a pamphlet." So she was kind of mocking pro-lifers, and she was going through a whole litany of our arguments that she thought were dumb, and that did not have a whole lot of credence to them. And it kind of made me mad. I stopped and I thought, never heard that one, huh? Well, my response to her was, well, I've never actually heard you respond to that. So we ended up getting in this back and forth. I didn't want to engage a whole lot, but it ended up that a woman that I do engage with sometimes on Twitter named Leah Torres, who is actually an abortionist out on the West Coast, kind of jumped into this whole thing. And she responded by saying that when someone cannot have a desired abortion, she is forced to carry the pregnancy and give birth, and that's offensive. This really captured my attention because I think it is really important for us to actively engage with the arguments that we're hearing from the other side, to try to figure out what is it exactly that they're thinking. How are they coming at this issue? And I was fascinated by this idea of forced birth. Forced birth. Because from our perspective, the idea that somehow we would look at this amazing beginning of a new life as something that is forced is really kind of awful. So my response to her, at some point I decided it was diminishing returns on Twitter, and I just responded hashtag Alice in Wonderland. Mm-hmm. And you can see what her response was. She says, "I don't know what that means." I thought that was particularly interesting because for me, I stopped and I thought, well, maybe I'm being a little too obscure with my reference here, but what was particularly interesting to me was my pro-life friends understood exactly what I meant. My pro-life friends understood exactly what I meant. And what I want us to think about this morning is the fact that we're at a really unique point in the debate on abortion, is that the abortion movement has become so entrenched in their Alice in Wonderland viewpoint of the world that we really are living in different realities. Their doublespeak on the reality of the unborn life has become so entrenched in their way of thinking that our entire culture has become shockingly calloused. Shockingly calloused. Why is that? Why is she able to talk about forced birth and along the way some other people came along and said that the answer to the fetus having choice is the fact that the woman's autonomy trumps the baby's life. The woman's autonomy trumps the baby's life. We've moved beyond, completely beyond the days of a euphemism about the baby. Think back, I'd say a decade and a half ago, where we were still talking about a clump of cells, different kinds of euphemisms that they would come up with to obscure the reality of the baby. But with the advent of the 4D sonogram and increasing reality that is undeniable of the baby's life, they've moved beyond euphemism into a new era of hardness. As a culture today, we understand that it's a baby. We understand that it's a baby. It is undeniable in this culture that it's a baby. But now, they just don't care. They don't care. I need to speed up a little bit because we have a remarkable panel in front of us, and Evangeline's job is to get out a hook and pull me off when I run over. And we do have people who are going to cover some of the other topics that I'm going to very, very briefly introduce. So I'm going to go very quickly and introduce a few concepts that will, I hope, foreshadow what's going to come over the next 2 hours as we're together. And my main point that I want to segue into and introducing to you is to capture this idea of the undeniableness of the life of the unborn and this growing callous, growing hardness in our culture and this cultural development with the law. So frequently people dichotomize culture and law. I'll hear people who say to me, I don't want to be involved with the law because the culture's where it's really at. And what I want you to see today is that this idea of turning away from the baby, closing our eyes to the baby, is actually entrenched in our law. And there's something we really need to be paying attention to. I'm going to skip over this because we do have our attorney panel. I believe Clark will probably talk about the underpinnings of Roe, and even back in Roe, we saw the development of this juxtaposition of the two governmental interests in preserving the right to abortion are the woman's health and the life of the unborn baby. The government has an undeniable interest in these two elements. I'm going to skip over this and move forward. The point that I want, well, actually no, I'm not. I'm going to stay with this. I want you to see that as early as in Roe, we had the justices telling us that the government was interested in the woman. So they said in Roe that a state may properly assert important interests in safeguarding maternal health, in maintaining medical standards, and in protecting potential life. The privacy right involved, therefore, cannot be said to be absolute. The privacy right cannot be said to be absolute. The state has legitimate interest from the outset of the pregnancy in protecting the health of the woman. This is coming forward to 1992 in Planned Parenthood v. Casey. Now there was quite a bit that we accomplished in Planned Parenthood v. Casey, but it was a disappointment in that it did not overturn Roe. So it's important for us to pause on this and ask why. What did we learn from that decision? And what we learned is that the court was telling us that even though they were going to preserve the right to abortion, that they were still interested in the health of the mother. So why did they not overturn Roe at that point? Why did we lose that argument? That's our key question. And the reason is this. Justice Kennedy told us that the court is concerned about the woman. They're concerned about the woman. And he said for 2 decades of economic and social developments, people have organized intimate relationships and made choices that define their views of themselves and their place in society in reliance on the availability of of abortion in the event contraception should fail. if you'll stick with me, there's a couple more elements of this that are absolutely essential. He went on to say the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. The Constitution serves human values, and while the effect of reliance on Roe cannot be exactly measured, neither can the certain cost of overruling Roe. The certain cost of overruling Roe. If you put yourself in the justice's seat, what they are concerned about, what they are hearing from the abortion lobby, is that if you overturn Roe, it will hurt women. That women need abortion. And why? This is the point we must not miss. Why do women need abortion? They need abortion. We as women need abortion for our place in society, to be strong, to be empowered. If you listen to them, this is what they talk about. This is why I started with talking about rhetorical dodges and how they're framing their arguments. We need to be paying attention. They are not talking about the baby. They can't talk about the baby because the baby is speaking for itself in every single sonogram that we post on YouTube. Every single sonogram that goes around the world with a click of a button. Instead, they want us to pay attention to Wendy Davis in her pink running shoes. In her 12 hours on the floor of the Texas legislature, did she talk about abortion? Of course she didn't. She wanted to talk about the fact that she went to Harvard Law School. And supposedly, abortion was an essential part of that. So our mission in this is to address this question of women's health. And this is why AUL believes that the new frontier in addressing Roe is to develop a mother-child strategy. Now, talking about this in the context of the March for Life is humbling, because in developing this strategy, we stand side by side with the remarkable men and women who have the courage to hold signs that say, "I regret my abortion," and to march up Capitol Hill and to stand in front of the Supreme Court and say, "You lied to me. You lied to me. There is no truth in this lie that abortion is good for women, that abortion is important to this culture. It's a lie." And we have brave men and women in this movement who refresh our enthusiasm, who undergird our commitment every day by being a part of the pro-life movement. We, as legal architects of the pro-life movement, want to link arms with those brave people and say there is a legal strategy that goes along with that cultural movement that is so strong. We need a mother-child strategy in our culture. We must not allow them to drive a wedge between the mother and her baby, between us and the important concerns that women have in our culture today. So undermining this reliance interest, this belief that the certain cost involved in overturning Roe is an undermining of a woman's position in our culture, is at the heart of the Women's Protection Project that we are talking about here today. I'm going to skip over this slide, although I want to introduce it because we have Dr. Monique Chareau, who is with us today, who's going to talk about abortion's harm to women. We need to be getting these facts out there about how abortion harms women. The data is out there. There is a conspiracy of silence in the medical community to keep women from knowing how deeply abortion harms women. So the Women's Protection Project is targeted at the state's interest in safeguarding maternal health. The Supreme Court has told us that an important governmental interest is in safeguarding women's health, and so our entire project is designed around a mother-child strategy to really focus the Supreme Court on the fact that both the woman and the baby are harmed in abortion. Let us never forget that in addition to the harms to the women who survive abortion,
are women who are dying across this country from abortion. And yet, there are no marches from the abortion lobby. They are so good at putting on marches, on putting on demonstrations, but where are the placards with Tonya Reeves' picture on it? Where are the placards with Holly Patterson's picture on it? Where are the placards with Jennifer Morbelli's picture on it? Where are the placards with Karnamaya Mongar's picture on it? Because this is a pro-life audience, I know that you know who these women are. Each and every one of them lost their life, not actually in an abortion clinic. No, they lost their lives in an emergency room. Because across this country today, women are going in for abortions and being told, if something goes wrong, go to the emergency room and don't tell them you had an abortion. How is that pro-woman? How is that defending women's health? It is not. Abortion is harming women across this country today, and there are women who are dying at the hands of abortionists, and they are not being held accountable. This is wrong. This is wrong, and it must stop. As I thought about concluding these remarks with these women's faces, and I put this together, I thought something really struck me about this. As you think about those faces that just went by, Tonya Reeves, a black single mother from the inner city of Chicago. Holly Patterson, a teenager from California. Jennifer Morbelli, a young woman, newly married, school teacher from the Northeast in her late 20s. And Karnamaya Mongar, a mother of 4 who had survived refugee camps before coming to try to live the great American dream here in our country. So different, each one of those women, so different from so many different segments of our culture and our society. And the one thing that unites them is abuse at the hands of an industry that claims to defend them. Let's remember their names today and tomorrow as we march. And thank you for being here today, for continuing a commitment of defending the most defenseless amongst us, the unborn in the womb who have no voice. Let us remember that their mothers, too, are abused by this industry. It's really my great honor to move from that and to introduce a colleague who I so appreciate the opportunity to work with, Clark Forsythe. Speaking of commitment and dedication, Clark Forsythe inspires me as I get to work with him. He's coming up on, Clark, it's your 29th. I wanted to say 30th. Okay, so we have to wait one more year to get you into the 30th anniversary. But Clark has been working with Americans United for Life for 29 years, and what an amazing resource this is for us as an organization, but also for the movement to have his deep commitment of his remarkable analysis. And he, as most of you know, I'm sure, he in September released a book called Abuse of Discretion, which looked at and revealed the construction of Roe v. Wade. It's so tempting for all of us to think that Roe v. Wade happened through kind of a natural process in the hurly-burly of American politics, but it did not. There was a deliberate movement to construct the right to abortion, to create it. And Clark has written a very dramatic and essential book for the pro-life movement. He's going to come join us and walk us through some of that this morning. Thank you again for being with us, and I hope you will stay with us for the next few hours as we think about the new frontier in Reversing Roe.
Thank you very much, Charmaine, and thank you all for coming this morning. I wrote Abuse of Discretion to solve the puzzle of Roe versus Wade. Why and how did the Supreme Court produce a decision that is so controversial 41 years later? I mean, by any objective standard, Roe versus Wade is the most controversial Supreme Court decision since Dred Scott in 1857, the decision which heightened North-South tensions leading up to the Civil War. Well, the conventional history of Roe versus Wade is that it was, quote, considered with special care, unquote. That's what Justice Powell said in 1983 in the Akron decision. And in Planned Parenthood versus Casey in 1992, Justices O'Connor and Kennedy and Souter said that Roe, quote, was a reasoned statement elaborated with great care, unquote. Well, that proposition is no longer defensible based on the record that we have today. The papers of several of the justices have been released over the last 10 or 15 years. And based on a review of those papers, abuse of discretion tells the story of the mistakes made by the justices and the unintended consequences that we're still living with today and that women are still living with today. Of course, what we call Roe versus Wade, what the culture commonly calls Roe versus Wade, is really two decisions, two cases from two states, Roe versus Wade from Texas and Doe versus Bolton from Georgia. And you can't really understand our national policy on abortion unless you read the two of them together as the court instructed. In Roe, the court suggested that the states could prohibit abortion after fetal viability, quote, except where it is necessary for the preservation of the life or health of the mother. But then in Doe, the companion case, the justices defined that health exception as, quote, all factors, physical, emotional, psychological, familial, and the woman's age, relevant to the well-being of the patient, unquote. That's why health in abortion law for the last 41 years has meant emotional well-being without limits. And that health exception in Doe swallowed the supposed ability of the states to prohibit abortion after fetal viability. So Roe and Doe together were sweeping decisions. And I was shocked by other things that I found in the justices' papers. First and foremost, Roe began as a procedural mistake. The justices took the two cases in April of 1971 from Texas and from Georgia, not to decide the abortion issue, not to address the abortion issue, not to declare a right to abortion, but to address and solve this mundane procedural issue about the jurisdiction between the state and the federal courts. But then 5 or 6 months later, a crisis erupted in the court in September of 1971 when two justices retired within the space of a week. Justice Black and Justice Harlan, who I argue probably would have voted against a right to abortion, retired within the space of a week due to ill health. Black died a week later. Harlan died at the end of 1971. That flipped the balance of the court, reduced the number of justices to 7, and it empowered a temporary majority of 4 justices, Douglas, Brennan, Stewart, and Marshall, to use the two cases to sweep away the abortion laws and declare a right to abortion. Without those twin vacancies, Roe versus Wade might never have happened, or at least come out the way that it did. And that's how the justices ended up with two cases with no trial, no evidentiary record on abortion or its implications, because they took two cases that decide the jurisdictional issue, which wouldn't have needed a record or a trial on abortion. But when the 4 justices decided to use the cases to declare a right to abortion, they chose 2 cases with no trial or evidentiary record on abortion whatsoever. Well, compare that with what Justice Brandeis once wrote in 1927 in a case called City of Hammond versus Shappy Bus Line. Brandeis wrote for a unanimous Supreme Court, quote, before any of the questions, which are both novel and of far-reaching importance, are passed upon by this court, the facts essential to their decision should be definitely found by the lower courts upon adequate evidence, unquote. So without any evidence, untethered from a factual record as judges need to be, the justices in Roe were susceptible to novel theories of history, of law, and of medicine. And to give one example, the outcome in Roe was driven by the medical myth that abortion is safer than childbirth. And there was no reliable data in 1971, 72 to find that abortion was safer than childbirth. No existing obstetrical textbook in 71 or 72 made such a claim. But based on that medical myth, the justices prohibited health and safety regulations in the first trimester when 90% are done, and created a public health vacuum that we see most starkly in Kermit Gosnell's clinic in Philadelphia and Stephen Chase Brigham's clinics in in Maryland and New Jersey and Pennsylvania. Then, after the cases were argued twice, and only a month before they were released, the justices arbitrarily adopted a viability rule that was never briefed or argued. The cases were, as I said, argued twice, in October of 70, or December of 71, and then again in October of 72. But in 4 hours of argument, the word viability is not mentioned once. And you can see this for yourself, hear it for yourself, if you go to the website oyez.org, oyez.org. And you can hear the original audios in the case. You can read the transcripts of the arguments. And viability is not mentioned even once. Listen to the original argument, the starting argument by the Texas Assistant Attorney General in Roe versus Wade, and you'll just be astonished and dumbfounded by the way the Texas Assistant Attorney General started the argument, and it went down from there, unfortunately. And there are various pieces of evidence in the papers that indicate that some of the justices didn't really understand what they were unleashing on the country. Some are in the book, Abuse of Discretion, but here's one additional piece of evidence. This is a letter dated March 16th, 1973, that's 7 weeks after the decisions were released, by Justice William O. Douglas to Chief Justice Burger. And he is telling Chief Justice Burger that he's not going to vote to hear a particular abortion case because he said, quote, "Our decisions in Roe versus Wade and Doe versus Bolton were confined to 2 conditions. First, that the abortion, if performed, be done in the first trimester. And second, that it be based on an appropriately safeguarded medical judgment," unquote. That's what he thought Roe versus Wade meant in March of 1973. So here are 3 reasons, I think, just to sum up, for why Roe remains so controversial beyond the sheer numbers of abortions and children killed over the last 41 years. Roe is way out of line with international standards. Roe isolated the U.S. as one of only 4 nations, along with China, North Korea, and Canada, that allow abortion for any reason after fetal viability. Roe is way out of line with American public opinion, which supports abortion only in certain circumstances early in pregnancy. And American tort law and property law and criminal law have rejected the viability rule which the court has imposed on the country for 41 years. The states have moved ahead with legal protection for the unborn children. We now have half of the states in this country with fetal homicide laws that extend from conception, and a total of 36 or 38 states with fetal homicide laws. Well, today I think that public opinion, public support for Roe is largely based on fear. The fear that overturning Roe, by overturning Roe, the court would make abortion immediately illegal. But the irony is that if Roe was overturned today, abortion would be legal in 40 to 45 states tomorrow, up to 20 weeks or up to fetal viability, for the simple reason that there are no abortion prohibitions on the books in those states, or that the state courts, because of state decisions, would prevent them from being enforced. The justices have assumed the self-appointed role of the National Abortion Control Board, but they can only monitor the situation in clinics by hearing cases. And they have repeatedly refused to hear cases. So they can't justifiably, responsibly, even assume that role and monitor it without hearing cases. Well, these are just some of the mistakes of Roe versus Wade that I set out in Abuse of Discretion. But the question remains, why do the justices stick with Roe versus Wade 41 years later? Why do they stick with Roe today, despite all the controversy? Well, lawyers are familiar with the distinction between the holding of a case and the rationale of a case, the what and the why. The court's holding in Roe is that there was a right to abortion. And the court's why in 1973 was largely history. Well, the holding of Roe is still the law of the land today in some sense, but the court abandoned the original why and shifted to the reliance interests that Charmaine mentioned in 1992 in Planned Parenthood versus Casey. Abuse of discretion tells how the court got us into this mess, and the reliance interests are the key to getting out of the mess. So now I have the pleasure to introduce Anna Franzanello. Anna earned her bachelor's in history from Franciscan University in 2003 and her law degree from Notre Dame Law School in 2009, and she joined AUL full-time as staff counsel in 2009. Her areas of expertise include protecting freedom of conscience. She's authored multiple comments to the Department of Health and Human Services addressing the inappropriate overreach of the HHS mandate and the insufficiency of the conscience accommodations suggested by HHS. She's also testified before the Institute of Medicine about preventive services, part of the Affordable Care Act. And her publications include Health Care Reform and Respect for Human Life, How the Process Failed, which was published, co-authored with Bill Saunders and published in the Notre Dame Journal of Law, Ethics, and Public Policy in 2011. And as you might expect, she consults frequently with state and federal legislators. And I gotta say, I'm glad that Anna is on our side, because I'm pretty sure if I debated her about anything, I'd lose. Please join me in welcoming Anna Franzanello.
It's really been a great blessing to work with Clark and Charmaine at AUL, and I want to encourage anyone that hasn't read Clark's book yet to pick it up. It's an incredible resource for the pro-life movement. Speaking of not incredible resources for the pro-life movement, on Friday I received an email from Cecile Richards, the president of Planned Parenthood, and in it she assured me that the pro-life movement wants to send women straight back to the 1950s. Although this was decades before I was born, I've been assured by abortion advocacy groups and even President Obama that the 1950s, despite its economic prosperity and family stability, was the pits for American women. This was the pre-Roe era with draconian laws that did not allow abortion on demand. And as Clark noted, Roe was built upon many myths. According to one myth at Roe's foundation was that legalizing abortion on demand would make abortion safe. However, Charmaine noted in one example, Tonya Reeves, a young African-American mother who bled to death after her uterus was lacerated during an abortion, was not the victim of a clandestine procedure performed before Roe v. Wade. Her future was not cut short by now convicted murderer Dr. Kermit Gosnell in his Philadelphia clinic dubbed the House of Horrors. The injury, which ultimately led to Tonya's death, was inflicted by an abortionist in one of Cecile Richards' Planned Parenthood clinics right on Chicago's Michigan Avenue in July 2012. Tonya's tragic death is one of the many examples that underscores that making abortion legal and available has not made abortion safe, and substandard clinic conditions are not the only cause of abortion-related injury and death. Whether accomplished by an invasive surgical procedure or by taking a combination of potent drugs, an abortion carries inherent physical risks for women. The undisputed risks of immediate complications, ones that even Planned Parenthood will acknowledge, include blood clots, hemorrhage, incomplete abortions, infection, and injury to the cervix and other organs. Abortion can also cause cardiac arrest, respiratory arrest, renal failure, metabolic disorder, or shock. Abortion also increases the risk of preterm birth in future pregnancies, which can have serious health consequences, and is the leading cause of infant death both globally and in the United States. Induced abortion is also a risk factor for women developing placenta previa in future pregnancies, which can cause severe bleeding before or during delivery and can be dangerous for both the mother and the baby. And as up to 75% of women who have an induced abortion, and that's 3 out of every 4, will become pregnant again, the impact on her reproductive future health and that of her subsequently born children is vital information to a woman considering abortion. But the physical dangers for women and their future children are not abortion's only risks. Unlike any other procedure, abortion involves the intentional termination of a human life, giving abortion a moral dimension with potential emotional or psychological consequences that a patient undergoing a tonsillectomy, for example, would never incur. Now, Planned Parenthood's website, Advice to Women Thinking About Abortion, does acknowledge that some women feel anger, regret, or sadness, with, of course, the caveat, for a little while. Perhaps a better gauge than the advice page for an organization that profits from each abortion that it sells is the decades of medical evidence that reveals that abortion carries significant psychological risk factors, including increased risks of depression, anxiety, and suicide. And as Charmaine also mentioned, there are thousands of women who have come forward and bravely shared their stories through campaigns like Silent No More in an effort to raise awareness of abortion's negative physical and emotional effects. But many abortion stories go untold and complications are unreported. That sad fact is verified not by just pro-life advocates, but abortion advocates. And at the time of the Gonzales trial, Susan Schul, for example, the executive director of the Women's Medical Fund, a group which actually provides abortion funding in Philadelphia, described her experience of trying to work with women to file complaints with the Pennsylvania Health Department. Ms. Schul explained, "The women found the complaint process so onerous and the telling of their stories so personally difficult that they failed to complete the paperwork and just abandoned their effort. And there was no avenue for Ms. Schul to file the complaints on their behalf. Complaints had to be filed by the patients." Another former employee of Planned Parenthood of the Heartland in Iowa, Sue Thayer, alleges in her whistleblower case that Planned Parenthood told its telemed chemical abortion patients who later experienced significant bleeding to just go to an emergency room and report that they were experiencing a spontaneous miscarriage. Countless other negative health stories go unreported because they go unconnected to the abortion that caused them. One nurse who left a Planned Parenthood in Delaware because of its meat market type assembly line care, her words, not mine, not because of any change of heart on abortion, testified last year before the Delaware Senate that the sad thing is that these women may not even realize the fact that Planned Parenthood could be at fault for these medical tragedies to both them and their future children, even years after they had their abortions at Planned Parenthood. But we're in an increasingly health-conscious society where we mandate fast food restaurants post-calorie counts, and where the U.S. Surgeon General routinely warns Americans about the health risks of smoking or being overweight, there seems to be little interest in ensuring that abortion comes with the warning label that it clearly deserves. Why? Because the health risks of abortion undermine that false narrative that's pushed by big abortion. Namely, that the debate surrounding abortion requires choosing sides between mothers and their unborn children. The truth is that abortion harms mothers and their children, even their children in future pregnancies. Highlighting abortion's harm to women does not ignore the humanity of the unborn, but it exposes at the core of one of the myths being used to sell abortion. It rejects that false paradigm of women versus the unborn that has been used to insulate the abortion industry. The truth about abortion's harm to women strikes at the myths that lay at the foundation of Roe. The pro-life movement is not actually attempting to take women back to the 1950s. We're forging a way forward, beyond our current state that pits mothers against their children, to an era that does not devalue motherhood and that does not use abortion as an excuse not to make institutional changes that truly respect women's equality. We are headed towards a day where both women and children will be respected, protected, welcomed, and thriving. And now editor-at-large of National Review Online. She is a nationally syndicated columnist who has been published by a wide variety of publications, including the Wall Street Journal, New York Times, First Things, the National Catholic Register, which I always get confused, the National Catholic Register versus Reporter Distorter, so Register is the good one, and Our Sunday Visitor. She is the director at Catholic Voices USA and speaks frequently on faith and public life, including on college campuses and on radio and television. She is a product of the New York City Catholic education and serves on a number of Catholic boards and is a member of the Archdiocese of New York's Pro-Life Commission. At the opening Mass of the Year of Faith in Rome in October 2012, Pope Benedict XVI presented her with a message to women throughout the world. Commonly known as KALO on the internet, on talk radio, and around Washington, she defies the myth that women need abortion to be successful, and we are grateful to her for joining us today.
Thank you, Anna, for interrupting my tweeting temporarily. That's what I was sitting up here doing, not my homework. Thank you so much. Just to continue what Charmaine was saying about the hardening and the death of euphemisms, I don't know how many of you are aware, because frankly, only about National Review Online was covering it, but Andrew Cuomo the other day, the governor of New York, is anybody from New York? Basically wrote pro-lifers out of the state and described this as right-to-lifers, saying that there's no room for that point of view in the state. But that he used the phrase right to life, I thought was remarkable and speaks something to the lack of engagement and almost a confirmation that that side doesn't have good arguments. It doesn't really want to argue, just wants you all to go away. But of course we're not. We're not leaving. New Yorkers are leaving the Empire State for today, for the march, but they'll be back, and they have a very strong presence, thankfully, as pro-lifers do nationally. I did have to laugh when I saw Rolling Stone had discovered AUL's stealth war about abortion. While I'm delighted they're noticing the rigorous legislative work of pro-lifers today, I do think they missed the story in the headline, which frequently happens in our short attention span culture. Sometimes the headline is everything, which is a very humbling thing for a writer who writes more than headlines to say. What we're doing here today, what so much of the work of so many of the people in this room today is about tenderness. You heard that in some of our speakers already, and love, compassion and help, reason and clarity, science, and a robust public witness to the dignity of human life in visible, practical, life-saving, and enduring ways. Clark Forsythe tells the truth of the history in his new book at a time 41 years after Roe was decided, where most Americans are not just ignorant of how Roe v. Wade came to be, but what exactly it is. We are not a people, as you all know, who held a vote and chose this, and we're not even a people fully aware of the preference toward abortion that our brutal cultural reality of changed expectations and false notions of freedom has led to. As Anna mentioned, a little over a year ago, I was invited by Pope Benedict to receive a message. The letter said, "For women throughout the world." Because the invite letter literally said that, and because of the power of the words, I try to share it as much as I can when appropriate. It was actually a message that had been delivered by Pope Paul VI at the end of the Second Vatican Council. And I think it's safe to say it wasn't heard in the 60s or the 70s or subsequent decades. So we try again to listen and live this and believe it. The message said, just in part, "You women have always had as your lot the protection of the home, the love of beginnings, and an understanding of cradles. You are present at the mystery of life beginning. You offer consolation in the departure of death. Our technology runs the risk of becoming inhuman. Reconcile men with life, and above all, watch carefully over the future of our race. Hold back the hand of man who, in a moment of folly, might attempt to destroy human civilization." And then it concludes, "Women of the entire universe, whether Christian or non-believing, you whom life is entrusted at this grave moment in history, it is for you to save the peace of the world." That's what the Catholic Church thinks about women, FYI. This no small role. And this is, of course, is not only a task for women, but we who love life, who see humanity, the humanity of the most vulnerable, must celebrate the unique gifts of women in rebuilding our culture together with men. We have tremendous opportunities right now. Not to be too papal this morning, and I'm not going on for much longer, but I think the fact that Time magazine thought Pope Francis relevant enough for their year-end cover is a confirmation of a lot of things we know about the renewal going on in our churches, in our communities, and even a little bit in Washington, D.C. The media, of course, misses when Pope Francis drops in on a pro-life march in Rome, as he did this spring, or when he says, "In all its phases and at every age, human life is always sacred and always of quality, and not as a matter of faith, but of reason and science." But like John Paul II, he's helped evangelicals and Catholics and so many other human rights leaders work together, I think, who help defending human life. Pope Francis is opening doors for us to enlighten, to talk about true freedom, and move us away from the poverty of the false conflict that so many speakers have talked about already between the mother and the child in our culture. And our culture is too content with being indifferent to this, or worse. to talk about the science the Pope even points to, and to talk about what we can do practically, politically, because we're not without solutions. This is indeed a time of and for new frontiers in making our culture more hospitable to life. AUL's Women's Protection Project is important because in providing legislative models to protect women and children, we can build family life and create a whole different kind of culture, the kind of culture so many of you model with your own lives, because this isn't just a job for you. Now, I'm so delighted to be here with these distinguished panelists, whose bios, of course, I have put at the bottom of the pile very conveniently, so I can gracefully bring them to the top. First, we're going to hear from Carter Sneed, who I've known for years, and am delighted that he has an important spot at the University of Notre Dame on the faculty and also director of a great bastion of pro-life and ethics there. We also have with us today Dr. Monique Chareau, who is a doctor doing important work in obstetrics and gynecology at Duke University, and is an unabashed defender of clarity on human sexuality, talking about abstinence and many other important issues that as a previous speaker has mentioned, there's just a scandalous lack of medical research and discussion about so many aspects of human life, women's health, which is really one of the big scandals of our time. That even one writer, Mary Eberstadt, has likened to the Cold War and the deniers during the Cold War. You just see science in front of you and won't talk about it. And then finally, we have Attorney General Scott Pruitt from Oklahoma, who is a great pro-life warrior on the state level, really showing a model of what legislators can do, what civil servants can do to help make the culture more hospitable to life. So we're going to start with Carter, give him the podium to talk a little bit about the legal aspects of the reality of where we are and where we can be going.
It's an honor to be here at this event. Americans United for Life is an extraordinary organization, and changing hearts and minds obviously depends on argument, but it also depends on witness, and there are very few witnesses like Charmaine Yost in the public square, an extraordinarily compelling person. In her person, she changes hearts and minds, as well as in her very sophisticated and compelling argumentation. So it's an honor to be here with all of you. My charge today is to talk a little bit, to take over from where Clark left off at the end of Roe and Doe, and to talk a little bit about the landscape, the legal landscape, which of course is disturbing in many respects, but it also has the seeds of a strategy that Charmaine and others have sketched out for the future. And I'll talk a little bit about what has to happen in order to overturn Roe versus Wade finally and ultimately, and also the things that we can do before that point. So to underscore something that Clark said at the beginning, Doe versus Bolton in many respects is more important than Roe versus Wade, because what it does is it creates this health exception that encompasses any aspect of a woman's well-being that essentially works as a veto, an abortionist veto, if you will, or at least originally worked for many, many decades as an abortionist veto over anything a state legislature such as Oklahoma or even the federal government would try to accomplish by way of protecting the unborn child. And in fact, and if you had any doubt at all about the capacity, the capaciousness of the health exception, all you have to do is look at this quote from late-term abortionist Dr. Warren Hearn, who pioneered late-term abortions. He said that he would certify any pregnancy is a threat to a woman's life and health, implicitly, and could cause grievous injury to her physical health. Okay? So the idea is, if you're pregnant, then you have access to the health exception. The only people that would not have access to the health exception, as determined by the abortionist, is a non-pregnant person, which, as you can see, is a paradox and allows for abortion on demand throughout 9 months of pregnancy, despite the fact that legal scholars, social commentators, and the media sometimes describe Roe v. Wade as the constitutional decision that legalized abortion in the first trimester of pregnancy. That is a woefully inadequate expression of what Roe v. Wade did. So fast forward from 1973 to 1992. Many people thought that the Supreme Court was poised to overturn Roe versus Wade. A lot had happened in the intervening years. Justices Scalia, Rehnquist, and White were on the court. They were all known to oppose Roe. Justices O'Connor, Kennedy, Souter, and Thomas seemed also sympathetic to the prospect of overturning Roe versus Wade. The laws at issue were laws that had been overturned, laws the likes of which had been overturned previously under Roe v. Wade's regime, which established the highest degree of scrutiny in reviewing any restriction on abortion because abortion was deemed by the justices in Roe as a fundamental right, which is the most important kind of right one can have in our constitutional system. The laws that were at issue were quite modest side constraints on the practice of abortion. They were informed consent laws for the woman seeking an abortion. There was a 24-hour waiting period. There was a parental consent provision. These are all from Pennsylvania. Governor Casey, the late Governor Casey, was in many ways responsible for these laws, part of the Pennsylvania Abortion Control Act. Spousal notification provision, which is exactly what it sounds like, namely a requirement that a woman must notify her spouse if she's seeking an abortion, but there was a bypass provision in circumstances where that would be dangerous or unworkable. There were reporting requirements for abortion facilities, and then they changed the definition of medical emergency in the state law to accommodate these other provisions. Unfortunately, and a heartbreaking result, in Planned Parenthood versus Casey, the three-judge plurality, Justice O'Connor, Kennedy, and Souter, affirmed what they called the core holding of Roe versus Wade. And what that means I'll elaborate on momentarily. But they did make some modifications. They altered the classification of the right to abortion from a fundamental right, which enjoys the highest degree of protection in our system, to a protected liberty interest, which is a downgrade. And then they replaced the trimester framework, which governed state restrictions on abortion. In the first trimester, there could be no restrictions. In the second trimester, the only restrictions could be driven towards the protection of women's health. And then in the third trimester, there could be restrictions on abortion subject to the life and health exception. They replaced that trimester framework with a pre-viability, post-viability dichotomy, which I'll elaborate on in a moment. But the question is, why would you affirm Roe versus Wade? Why would these people, these justices, who had in their past statements seemed quite skeptical of Roe, as were most legal scholars, Lawrence Tribe, John Hart Ely, even Ruth Bader Ginsburg, had criticized Roe as lawless and arrogation of authority by a court without really meaningful argumentation. Clark details this beautifully in his book. Why would you affirm Roe versus Wade? And if you look at the three justifications the court sketched out in Casey, it's chilling in many ways, but and problematic to say the least. But embedded in that opinion and subsequent opinions, there are some grounds for optimism and some instruction for the future. But the first argument was a substantive argument of what was now called a protected liberty interest in abortion. Roe versus Wade was about privacy. The rationale, the ground of the justification shifted from privacy to liberty. Since 1973, Roe versus Wade has been simply an arrogation of power and assertion of authority in search of a justification. At first it was privacy, now in 1992 it was liberty, now there's yet another normative justification for it, equality, which I'll talk about in a second. But you get a sense of how unstable Roe is because it's so lawless and so incoherent, morally incoherent and legally incoherent, that the justices have constantly tried to reverse engineer a rationale that makes sense. And the effort in 1992 was, well, there's a protected liberty interest, and this part of the opinion, even though it's signed by the three-judge justice plurality, is most frequently attributed to Justice Kennedy, who, as you can see in his other opinions, focuses on liberty as the primary animating norm in his jurisprudence. He said, in this opinion, we cannot impose our own moral code on abortion, which, as we all know, makes no sense because, of course, it's the imposition of a moral code to give a woman an absolute right to an abortion. And moreover, abortion is not at bottom a moral question. Of course it's a moral question, but at the end of the day it's a question of justice. It's a question of who is entitled to the protection of the law. And that's not a question of private morality. That's a matter of public justice, as we all know. So off to a bad start with Justice Kennedy in this opinion. And in one of the most mocked passages in American jurisprudence, we have this passage which says, at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and the mystery of human life. Now, if you're in a freshman dorm late at night, you might hear one of your classmates say something like this after a little too much Ayn Rand. You might read something like that. It's shocking and disturbing and terrifying to have it in the U.S. reports where the Supreme Court opinions are published. It can't possibly mean what it says on its face. It can't possibly be true that I can define, it's my right to define, is it your right to define what life means, when it begins, of the universe, and so on. That's a formula for anarchy and can't possibly mean what it says. And then it turns to the suffering of the woman, which is a very serious thing, of course, and something that we're sensitive to and have to be. And Charmaine has spoken quite beautifully in a moving way about this, about the woman who is facing the unintended pregnancy. And that is a major element of this rationale here. They said the destiny of this woman must be shaped to a large extent on her own conception of her spiritual imperatives and her place in society. And of course, we would all agree with that obviously a woman has a right to make key decisions about her well-being. But the problem is that right ends where the right of another human being begins, namely the unborn child. For the lawyers in the room, you'll recognize this, the concept of stare decisis, that is, let the decision stand. It's a prudential concept in common law traditions that you shouldn't disturb prior precedents without good reason because of the reliance interests that have built up over time in those precedents, the reliance that Charmaine mentioned in her remarks. And there's a pretty well articulated formula for the doctrine of stare decisis. When it's in prudence sensible to overturn prior decisions, when the prior decision has become intolerable by defying practical workability, and then you take into account questions of reliance and whether the doctrine announced has been abandoned, whether or not the facts have changed to undermine the previous holding. All of these obviously clearly counsel in favor of overturning Roe versus Wade, but of course the justices didn't do that. Instead, what they said was, and this is chilling as well, what Charmaine had said, people have organized their lives around a robust right to abortion. And that, by the way, is true of many horrible institutions in American society and culture. People organize their economies around horrible violations of human rights in the form of chattel slavery in America, and that, of course, would never be taken seriously as a justification to sustain those sorts of inhumane laws. But in any event, the court simply said, applied without real argument, and based on contestable and in some ways facially risable premises that, of course, all the principles of stare decisis lead us to affirm Roe. The third rationale is the most disturbing in many respects. The court said the legitimacy of the court itself in the minds of the American public depends on sustaining Roe versus Wade, whether it was rightly decided or not. The court even says, they said that even if there was, it would lead to a profound and unnecessary damage to the Supreme Court's legitimacy, to the nation's commitment to the rule of law, to do this, and it would look like we're surrendering to political pressure and an unjustified to repudiate this principle. Now, you don't have to be a genius to see that affirming Roe versus Wade could also seem like a surrender to political pressure and an unjustified repudiation of principle, or a failure to assert a principle. So this is in many ways an incoherent rationale, but more deeply, the Supreme Court tied its own prestige and its own legitimacy as a co-equal branch of the federal government to sustaining the most lawless and morally incoherent and inhumane precedent of the modern constitutional era. And that is shocking. It's shocking that the most discredited holding of recent decades is the linchpin of the court's legitimacy and its prestige. And if it were to overturn that, it would undermine its own prestige. Well, the fact that we've been marching for 41 years, starting tomorrow, is an indication that this is a terribly incoherent moral calculus, and they're badly confused about thinking through this proposition. Right after explaining that the court's legitimacy depends on sustaining Roe versus Wade, they essentially they told us pro-lifers that we should go home now. We should go home now because the court has called the contending sides of this national controversy to end our national division by accepting a common mandate rooted in the Constitution. Well, tomorrow we're going to give them an answer to that invitation to stay home and to go away. However, despite these deep problems in Planned Parenthood versus Casey, there are some grounds for optimism, and there is some kind of a roadmap for a strategy going forward, and it becomes very clear what has to happen to overturn Roe entirely. As we've heard earlier today, the court did soften its abortion rights rhetoric a little bit, and Justice Kennedy is in many ways has sympathy for the unborn child in a way that's different from some of his other colleagues on the court, and I'll elaborate on what I mean by that momentarily. But they said the state has a legitimate interest from the outset of pregnancy in protecting the health of a woman and the life of the fetus that may become a child. That's a strange ontological assertion there, but the fetus that may become a child, I'm not even sure. I don't want to even deal with that. But the court concerned that Roe and its progeny did not create sufficient space for state action that signaled respect for unborn life. Justice Kennedy and others thought Roe versus Wade is too much of an absolute victory for the abortion rights movement. We need to give states, great states like Oklahoma, for example, more space to signal their respect for unborn life and to protect the health of women as well. And so what the court tried to do was to try to recalibrate the balance that Roe versus Wade struck, which wasn't really a balance. It's more of an absolute victory for one side of the dispute. They said, okay, what we're going to do is we're going to say before viability, the state may not unduly burden a woman's right to abortion. After viability, there's a different standard. But before viability, the state may not unduly burden a woman's right to abortion. This is a concept. The undue burden concept was a new concept in constitutional law. Usually, if a law is not if a right is not a fundamental right, all the state has to do to burden that interest is to satisfy a rational basis, which is a very low bar indeed. Undue burden sounds a little bit like rational basis, but it's not really entirely clear what it means. But the more important normative question is why viability? What's so important about viability? And truthfully, the court never actually ever elaborates that point. They have one sentence on viability in its 41-year jurisprudence of abortion, and it's a tautology. They say, viability is the moment at which, in reason and fairness, the independent life of another individual can be the object of state protection. Well, that's a circle, right? Viability makes sense because viability makes sense, is basically what that says. They've never really explained it. You and I could speculate about why viability, and all the reasons are not satisfying, right? Is viability important because the baby is less developed? Was the standard then that, because we all know that the human life begins at conception, the life of the organism, basic embryology begins at fertilization and then moves along a sort of seamless trajectory through birth and all the stages that come after birth. So the question becomes, who counts, which human organisms get to protection of the law and which don't, and the argument from viability seems to say that the less developed you are, the less protection of the law you get. Maybe it has to do with bodily dependence on the woman, but that sounds morally incoherent as well, doesn't it? That means the weaker you are, the more dependent you are, the less protection of the law you get. Well, that stands on its head our best moral traditions that weakness begets protection. Weakness invites defense. Weakness does not mean that you're entitled to less protection. It's morally upside down. So none of the justifications for viability. Viability, as most of us in the room know, is simply a function of lung capacity, and it's a shifting line. It depends on, first of all, it depends on the individual child. It's highly contingent, and it moves. The line moves back as medical technology becomes more available and more developed. So it's a very strange line to draw the difference between life and death, who gets the protection of the law and who doesn't. So it's not entirely clear, but before viability, the state may not unduly burden a woman's right to abortion. One might wonder, what does that mean? What constitutes an undue burden? Well, what the court says instead is they don't give us an answer or an explanation. They give us a synonym. They say a substantial obstacle is an undue burden. However, they immediately say the states may impose structural mechanisms to express profound respect for the life of the unborn. That's permissible, even if, and they can be designed to persuade women to not choose abortion, even if it makes it more expensive or more difficult to get an abortion, even if that regulation has an incidental effect of making it harder to get an abortion, that's okay. That's not an undue burden, according to this definition. And they give the example of informed consent. And at the end of the day, the court affirmed every single law that was challenged, except for spousal notification. Justice Kennedy affirmed every single law, informed consent, 24-hour waiting period, definition of a medical emergency, and so on. The court, every single law, every single aspect of the law in Pennsylvania was affirmed after this decision, even though it had the heartbreaking result of not overturning Roe, and even more importantly for our purposes, not overturning Doe versus Bolton's definition of health, because even after Planned Parenthood versus Casey, the abortionist veto remained in place. The definition of health, capacious, decided by the abortionist, including every aspect of a woman's well-being, stayed in place. Well, we can fast forward past Stenberg versus Carhart, which is a 2000 case involving state partial birth abortion bans, move to 2007, which is a moment which has some additional lessons for us. We all know what partial birth abortion is. I don't have to elaborate on that. The federal government, after the states' laws were struck down in 2000 on a 5-4 decision, the U.S. federal government passed a law in 2003, the Federal Partial Birth Abortion Act, which did essentially the same thing. It banned these abortions and did not include a health exception in a sort of frontal challenge to Doe versus Bolton. Well, Justice Kennedy affirmed the bans on partial birth abortion, and also he made it clear that even in the face of medical and scientific uncertainty, states can legislate. States can take a position on a contested question, even if there are medical experts who disagree, even if there are abortionists or the American College of Obstetricians and Gynecologists disagree. If there's substantial medical evidence on the state side, they can take a position and act accordingly. And that is a huge, huge important thing for going forward. There's wonderful language from Justice Kennedy about the fetus being a living organism while within the womb, whether or not it's viable outside the womb. And then Justice Ginsburg announced a new normative ground for abortion, namely equality. Women's equality depends on access to abortion. And this gets to what Charmaine was saying. They can't argue the unborn child is not a child. So they have to say something like, we don't care. They have to say something like, well, nevertheless, even if it is a child, a woman has a right to abortion, because if she engages in the same kind of sexual behavior as a man and she becomes pregnant, in order to be on an equal playing field with men in terms of citizenship, social equality, economic equality, she has to have recourse to abortion to undo the damage that was done by her pregnancy. And equality demands. Now pause a second and focus on how incoherent that is. The idea that equality depends on entrenching in the law the most inegalitarian proposition we've seen in modern constitutional history, the idea that some people matter and other people don't, some people count and other people don't. Entrenching that radical inequality for unborn children is the mechanism by which you advance women's equality. That's a theory that's at war with itself. Casey was not reaffirmed, interestingly, by the justices. They simply assumed that it applied to the case. But the hardest question remained, namely, there was no effort to justify why the right to abortion exists in light of the moral status of the unborn child. So for the future, we have 4 justices who would almost certainly reverse Roe versus Wade. Thomas, Scalia, Alito, and Roberts. We have 4 justices who would not only affirm Roe versus Wade, but even strengthen it and restore it to full strength and reestablishing it as a fundamental right, probably grounded in the equality of women, which would overwhelm any state action to try to undo restrictions on abortion. Kennedy, for the moment, is our abortion czar. Every restriction on abortion has to come up, and he gives it the thumbs up or the thumbs down, which is a problem for self-governance in any kind of system. But Justice Kennedy has affirmed every restriction on abortion he has ever encountered except for spousal notification. So what's the future then? One, and this is the brute fact, elections matter. You cannot do anything long-term on the Supreme Court without a president who is pro-life and who's willing to appoint pro-life justices. That's really, I mean, it's very simple, but it's true. You cannot overturn Roe versus Wade without a personnel change on the Supreme Court, and the only way you get that is with a president who is pro-life. In the meantime, there are strategies that we've seen embedded in these precedents to push harder against the definition of health. Justice Kennedy seems open to that possibility. He's invited us directly to pursue robust informed consent laws in the name of protecting women, in the name of maternal health. We've also seen an openness, at least in some of the rhetoric of the opinions, to identifying new and additional state interests that might warrant restrictions on abortion. Justice Kennedy said in 2000 that we've not exhausted the list of state interests that would warrant restrictions on abortion. And this goes to the heart of what Charmaine and AUL wants to do. We have to, in our witness, in our legislative activity, and in our personal lives, show that the pro-life movement cares more about women and their babies than the abortion rights movement. And that's pretty easy to do. We've been doing that for 41 years. But the message here is, we love you, we love your baby, and we're here to help. That is the message of the pro-life movement. It's always been the message of the pro-life movement. And that is how we will continue to engage this debate vigorously, tirelessly, but with charity and civility. So thank you all very much.
Catherine, thank you very much. It is a joy to be here with you today. I was not a Boy Scout growing up, and it bears out today. My Solicitor General is here with me today. We didn't bring a coat to Washington, and I understand there's a snowstorm coming. Wow, that's ill preparedness. But we try to be more prepared legally on the issues that we deal with. I thoroughly enjoyed the professor's comments. Maybe we can do it online, Catherine. I don't know if we can do that as an extension course or not. I can't go to Indiana and attend Notre Dame class there at Notre Dame, but I thoroughly enjoyed your comments. And Anna, I understand that you were a student, and with the professor, your comments this morning were outstanding. I appreciated your comments. I want to start, and I am joined with my Solicitor General, Patrick Wyrick. We had 2 cases this past year in 2013 that many of you know were on the way. In fact, the court actually took jurisdiction of one of those cases in the Nova case, and we thought we were going to be here before the Supreme Court this year, and ultimately did not happen. But Patrick's been a great champion with me, and as an extension of our office, fighting these issues on behalf of Oklahoma's interest and the interest of women and children, and really appreciate his partnership. I want to speak big picture just for a second, that I think when we come to gatherings like this, I think we need to be reminded this is more than an academic setting. These are fascinating topics that we're talking about. These are, I'm inspired. In fact, I was asking the professor as he sat down, I want to talk to you about one of the things that you mentioned, and perhaps we can unpack it later. But this is more than an academic setting. We need to keep in mind that these issues are big issues with respect to the lives of children and women. And we need to keep in mind also that sometimes we grow disheartened with respect to this battle that we're on. The professor mentioned Planned Parenthood versus Casey. I was in law school at the time. I know I don't look that old. I'm still vigorous and don't play baseball like I used to, but watch my kid play. But, I was in law school at the time, and there was a disheartening effect with respect to Planned Parenthood versus Casey. And I think this long journey that we've been on with respect to both state laws that are passed and the court battles that we see and the presidential elections that we engage in, we have all these various fronts, and sometimes when we lose or there's a setback, we get discouraged. And so I want to say to you one thing. Don't be discouraged. Don't lose the fire. Don't lose the passion. Think of that gentleman, William Wilberforce, that took on a great, great challenge during his century. And you know what William Wilberforce was about? He was about the abolitionist movement there in England. And the battle that he faced was no less a battle. Obviously, it's equal to what we engage in today. And so we've got to grow, I think, optimistic in our view. And that's part of what we're actually talking about with the laws that are being passed at the state level. These are optimistic. These are really laws that are being passed to advance the interest of both women and children, but to inform them and to help them make a decision so that when they're 20 years beyond that decision, they don't look back with regret. And that's important. So I wanted to first start there, and also wanted to say to you that General Douglas MacArthur had 2 questions he asked. He said, I read this in a book many years ago, he said, before you enter any battle, you should ask yourself 2 questions. Is victory believable, and is victory achievable? And the believability part is something that's very important, because that is the part that says we can go forward and make a difference. And sometimes that's the disheartening aspect where you draw back and you shrink from making the changes or advancing the changes. But the achievability part is really where I want to camp today. Because we've got to have a plan in place at the state level. And I see Dan in the back. You're all doing a great job in the state of Oklahoma. You're doing a great job across the country at working with legislators to inform and educate and to give them a plan on how to achieve what they can achieve from a policy perspective. So I really appreciate that, the partnership of AUL. I was actually in the legislature from 1998 to 2006, and at that time AUL was not on the ground. And so I really appreciate the addition of AUL across the country to the battle and to the focus of advancing life. I want to really address predominantly the role of an attorney general and what we are dealing with respect to these issues involving life. I actually have some ideas at the end that I want to propose to you with respect to some maybe new fronts that we need to consider that we've talked about in our office. But first let me begin that many think that with legislators and the legislature, the respective legislatures across the country, that attorneys general are automatically the legal advisor of those bodies or those individuals, and that's just simply not the case. In Oklahoma, unfortunately, my office is not in a position to automatically and formally and required to provide analysis around the constitutionality of the law. It's very informal. And that's troubling. And I would say to you that in the various states across the country, the more that you can do to have your Attorney General be involved with the pro tem, the Speaker of a legislature, and the governor in the preparation and the adoption of legislation, it's important. Because at the back end, who's defending it? The Attorney General. And so it just makes sense that the Attorney General should be involved on the front end. In most states, that's not the case. Now, in our office, we've been very aggressive. We've got leadership in both the Senate and the House and the governor's office that we have great relationships with, and we work with them consistently. We worked with them on both the NOVA and NOVA 1 and NOVA 2 cases, the ultrasound case, and the other matters that were on their way up to the Supreme Court. We worked with them and gave them advice and counsel. But let me say this to you also. It doesn't matter how good a job you do at drafting legislation. It doesn't matter how good a job as far as the cohesion and the work that you engage in from an AG and the legislature and the governor. You could have the most constitutionally pristine and sound piece of legislation that ever was drafted and adopted, and it's still going to be challenged. We start, and you should start, from the premise that every pro-life piece of legislation is going to be challenged. In fact, NOVA and other organizations travel the country, and they do this in Oklahoma, and they threaten and they intimidate and they actually say in advance, why are you wasting time passing these laws? They're simply going to be declared unconstitutional. And I will tell you that even in places like Oklahoma, and I think the individuals that's in this room from AUL and others would tell you that even Oklahoma, there's some persuasion there. The opinion leaders and the editorial boards and the newspapers and the media overall start questioning legislators and the governor in our office on why are you wasting the state's money advancing legislation that ultimately is going to be declared unconstitutional by a court. Now, that's a false statement, but that's where they begin. And so it makes it much more incumbent upon those that are passing laws to do so with a commitment, a rigorous commitment, to dot every I and cross every T, and to make sure that it's prepared for that challenge when it comes. So things need to change at the state level. Things need to change across the country, but particularly in Oklahoma, we don't, for instance, we don't make a record. Oklahoma's not Washington, D.C., and most people in Oklahoma say, thanks for that, that it's not, in light of what's going on in Washington, D.C. these days. But one of the things that happens here that is good in the adoption of policy and the passage of laws is there's a robust record that you can look at and determine what was the intent of the Senate, what was the intent of the House, what was this particular piece of legislation intended to address. And it is very important for states with respect to pro-life legislation to take an approach of identifying legislative intent up front and making a record in the committee process, particularly with scientific backing and data, medical data, and the intent that it's supposed to address as far as the legislation. It's very important. And it's not happening in Oklahoma, and I don't think it's happening across the country. So that's one of the things we're encouraging our legislators to do, and they're responding because it does give us something to defend on the back end. The other thing I think we need to recognize in this room today is that the strategy being implemented by the abortion industry is very creative at this time, in the sense that they are developing a state-by-state strategy, not just to come in and through media and through intimidation or communication to basically say don't pass any state laws, but they are challenging the statutes that are passed, not in federal court, but in state court. Now think about that for a second. The whole analysis that you've heard today so far from the professor and before was based upon Supreme Court jurisprudence. What is the state of the law? How do we respond to it? How do we pass statutes that conform to the issues that you've heard today or the tests that you've heard today? But the abortion industry has opened up a new front. And the new front is we're going to disregard the entire federal landscape and go state by state to establish what? A constitutional right to privacy under state constitution. A greater right than what exists today under federal law. How do we know that? That's what happened in Oklahoma. The case that was on its way up to the U.S. Supreme Court was a case that was actually filed in our state court. It was not filed under Planned Parenthood versus Casey and all the following cases. It was a claim that said that our state constitution in Oklahoma provided an unfettered, unqualified privacy right to an abortion. And you know that the federal constitution is a floor. So states can obviously provide additional protections beyond the floor of the U.S. Constitution, and that's what the abortion industry is arguing. And that's what they did argue in the Nova case. So this battle is very important because we have to be prepared to respond to that. So what does that mean? Judicial selection. You heard the professor say that who you elect as president matters on the pro-life front, and it does. But I would say, too, it equally matters who you elect as governor in the various states. You need to look at the judicial selection process in each of the 50 states and ask yourself, what is the makeup of the court in those states? Because that front is being opened up, and we may see, what if Roe versus Wade was overturned tomorrow? But yet the abortion industry was successful going state by state in advance of that, establishing a state constitutional right through the various Supreme Courts across the country. So as an AG, we're on the front end, hopefully, most of the time. We're there to encourage them to make a record and to establish legislative intent with respect to defending that law on the back end. We're there to obviously defend those laws as they are passed, because that is our responsibility as the chief law officer of our respective states. And we're there to hopefully be involved in the judicial selection process, giving voice to our citizens across the state of Oklahoma and other states on why it matters, who serves in that role at the state level. But there are a couple of areas that I would say to you that I think are also some new opportunities. I'm encouraged when Justice Kennedy says, look at opportunities with respect to advancing the interest of women. One of the primary responsibilities of an attorney general, as you know, is the enforcement of consumer-related statutes. How did the lady show up at the clinic to begin with? How did the young lady or the woman show up at the clinic to begin with? What marketing, what representations were made to encourage her to be on site? And who processed her when she arrived at the clinic? And was it fair and honest what she was told, or was it deceptive and misleading? And so one of the areas that I think we need to look at on a prospective basis at the state level, particularly from an attorney general perspective and enforcement of consumer-related statutes, is what can we do to strengthen our consumer-related statutes as it relates to abortion, as it relates to the marketing that is actually in the marketplace, as you know, to encourage individuals to obtain abortion. And it goes beyond informed consent. And that's one of the areas we're looking at in the state of Oklahoma as far as trying to strengthen that. And then obviously one area in addition is the clinic experience in itself. You know, from outpatient surgery, outpatient procedures versus what the responsibilities are by rule for hospitals in the respective states. So advancing very tight controls on disclosure and also the clinic that's providing the abortion, making sure that informed consent and the safety and health of that clinic experience is advanced with respect to the process itself. So those are some new opportunities that I believe exist that we need to explore from a consumer perspective, as well as from a Department of Health in the state of Oklahoma and other states across the country. And I would just close with this. You know, these areas, I don't want to understate the threat and the intimidation that and how much that plays in whether laws are adopted in the first instance. I said rather quickly that even in Oklahoma, that these groups come in and offer this type of, why waste the time, why waste the state's money in passing laws that you're going to have to defend in the court process. And there are some in the legislative bodies that are starting to listen to that. When you have tight economic budgets and you have all that we see going on from a budgetary perspective in D.C. and that flows through to the states, those that aren't truly motivated by the burden of advancing life they start thinking, economically, and they start thinking very pragmatically. And these groups know that, and that's the reason they come in and say, don't pass any laws, don't expose the state to that type of liability potentially, because it will cost the state money. You have to respond to that from a public policy perspective and from a government relations perspective. You've got to help those individuals understand that it's not whether it's a sound piece of law that's been passed. It's not that they have failed to do a good job in making a legislative record. The challenges are just going to come. And you have to be accepting that the challenges are just going to come. In the state of Oklahoma, we don't hire outside counsel. It's me as Attorney General and my solicitor that defend the state statute. And I pray we do it well. It's our job. And so when people ask me that on why are you wasting the state's money in defending these statutes, why aren't you telling the legislature to take a different path, my response is twofold. One, because it's an important concern in the first instance. We ought to be advancing life and doing our job from a state policymaking perspective. But as Attorney General, we exist to defend that which the legislatures have passed. And I want you to know that as long as I'm Attorney General in the state of Oklahoma, not only are we thinking about ideas that can be put forth to the legislators to advance the state's interest and the role that we play, but we're going to say unapologetically, we're there to defend that which the policymakers do. Teddy Roosevelt had a great statement one time. He said, in any given situation, the best thing you can do is the right thing. The next best thing you can do is the wrong thing. The worst thing you can do is nothing. I'm thankful that I'm in a room today of folks that say we're going to charge the hill. Keep charging the hill. It matters. It matters to the life of the unborn. It matters to women. It matters that we work and collaborate together. And it matters that we have a multifaceted strategy in responding to those that are seeking an unfettered, unqualified, abortion on demand perspective with respect to these issues. We need to fight back, and we are. And I thank you that you allow us to walk with you, and we look forward to doing that in the future. Thanks very much.
And next we have Dr. Monique Chereau. Again, in addition to being an assistant professor at Duke, she also is a staff gynecologist at the Durham Veteran Administration Medical Center. Her work is not just academic, as the Attorney General said. We're dealing with issues, obviously, of real people's lives and concerns and pains and struggles, and medical doctor knows that well. So please, thank you.
It's a real pleasure for me to be here, an honor actually. No other situation where an obstetrician will be as comfortable in a group of lawyers, I might say. But I'd like to talk today very much in harmony with a lot that has previously been said about the risks of abortion, and then expand possibly to some other areas. I am very much aware of the impact of abortion as a practicing obstetrician. I do not do them, I've never done them, but I was forced to deliver second and third trimester abortions during my training. So I know what I'm talking about with that area, as well as caring for women who had had abortions and presented, were told to go to the emergency room, and who were critically ill and needed surgery. And I'll talk about that a bit more. So next slide. So, of course, the justice's decision has given rise to a number of unintended consequences, and many of these have shaped the discourse in reproductive health. Next slide, please. I have quite a bit of ground to cover, so fasten your seatbelts. And so one of the things I want to discuss is the need to evaluate some of the medical and scientific evidence as the continuing debate about Roe evolves. One of the things that's been very clearly set forth is the states have a compelling interest in maternal health. This is for a number of reasons, and this is coming from the perspective of an obstetrician who does do some legislative work. Pregnant women, and by extension unborn children, are extraordinarily vulnerable. They're vulnerable physically, emotionally, and mentally. They're easily victimized. And then, of course, death, injury, and disability of a pregnant woman or recently postpartum woman is a devastating situation for the community. And finally, for the bottom line, netted out folks, pregnancy complications are costly. They're very costly. So this is a quick, thank you, that was good. This is CDC's most recent morbidity and mortality report on abortion surveillance. One of the reasons that I bring this up fairly frequently when I'm talking about abortion is that, number one, abortions are slowly dropping, okay, especially if you look at different, whether you look at the numbers, the rates, or the ratios, they are decreasing. And in addition, if you look at the proportion of abortions and the distribution by age groups, this is changing as well. What this slide is showing is that the highest rates of highest abortion ratios are in the less than 15-year-old age group, which is very striking. Why is that striking? For several reasons. One of the most important reasons is that a high percentage of these pregnancies are statutory rape. The person who has made this young woman pregnant is 7 years or older. They're involved in trafficking. They're involved in prostitution. They're involved in molestation. So that's a very, very important statistic. In addition, you can see that as women become older, they're less likely. But again, you have this big spike in the 20 to 24-year-old age group. Why is this important? Again, who should we be targeting our message to give some insight? I'm not sure how effectively we can target to the under 15 group simply on the face of it, but we need to be thinking about that. Next slide. This is the percent distribution of gestational age. Now, again, this is extremely important. The white bars at the top are abortions that are performed at greater than 13 weeks gestation. So again, you can see those are concentrated in the younger than 15-year-old age group, and also in the 15 to 19-year-old age group. Why? Because there's often a reason why these girls, or the person who got them pregnant, hide their pregnancies. And so therefore, this is the group of women that is most likely to experience morbidity and mortality from late abortion, is in the younger age ranges. Go ahead. The purpose of this slide is to make a point, and again, for people involved at the state level, our abortion surveillance, abortion statistics are woefully inadequate, okay? If you look over here, it says that Alaska, California, Louisiana, Maryland, New Hampshire, and West Virginia did not report abortions during the entire decade the CDC has been collecting data, or for specific years within the decade. California alone is an enormous, it's got to be, we have no idea what's going on with abortion in California. So this is something to work at the state level, is to improve surveillance, yes. And then, of course, we basically have two ways of estimating abortion incidence in the United States. One is CDC data, one is from Alan Guttmacher. Go ahead. So if you look at the sources of abortion data, as I mentioned, Alan Guttmacher, AGI, is a source of data. I'm not really happy to have to look at their data, but anyway. But they only collect data from 95 facilities. But one of the things that this does is to help us to understand why women have abortion. So in 2008, which was the last year that they collected data, the majority of women who had abortions were in their 20s in this particular study. Now again, CDC data shows us something differently. It shows that the greatest numbers of abortions are in younger women. The overwhelming majority, 85% are unmarried, 29% were cohabiting, about half had been in a relationship for a year long with a man who made them pregnant, 42% of women were poor. Women who were married and had a religious affiliation were less likely to have abortion. Also, interestingly enough, most women paid for their abortion out of pocket. Even if they had private insurance, even if they had Medicaid, they paid for their abortion out of pocket. Next slide. Okay, so at present, approximately 1.3 million abortions are performed in the United States. It's one of the most commonly performed procedures in the United States. I'd like to talk a bit about the abortion epidemiology of abortion outcomes. This has already been discussed a little bit, so I'll kind of fly through this really quickly. Maternal morbidity, infection, bleeding, uterine perforation. As I mentioned, I once had a case where a woman rolled into the emergency room with perforated uterus and bowel injury and was in the hospital for 2 weeks and was extremely ill. And I called the abortionist to confront him. And I said, you knew that you perforated her at the time that you did her abortion. You knew this. And he said, well, and he just got very frantic and started saying, well, you know, she was moving. I said, no, this is a procedure that needed to be done under general anesthesia. There is no excuse for this. And there's no excuse for the fact that you did not take care of her. You told her, you dumped her in the emergency room. and that was wrong. And so to his credit, he said, I shouldn't have done that. He kind of went on and on. But again, this is a major issue, which is that unrecognized injuries occur, especially in late-term abortions. Unrecognized injuries occur, and these women are not detected as having abortion-related morbidity because their outcome occurs 2 to 3 days after the procedure. Go ahead. And of course, we heard about mortality. Long-term complications, these are a few, and I'm going to go into these in a bit more detail. Keep going. So one of the issues, and I think I may have talked about this in the past, some of you may have seen this, is this is probably the best study we have about risk factors for legally induced abortion-related mortality in the United States. The study is from 2004 in the Green Journal. This will never be replicated at this point in time, but it's the best data that we have. Keep on. This shows by state. If you're ever interested in looking at the study, it's Bartlett et al., 2004, and it goes state by state and looked at the number of abortions and the mortality rate by state. Keep going. It also looks at, now this is mortality. This is not morbidity. This is women who die from having an abortion. And you can see again, the abortion rate, the mortality rate increases dramatically with gestational age. In other words, the more pregnant a woman is, the more complicated the procedure becomes. Keep going. And then this again is showing, again, the mortality rate in first trimester abortion at 8 to 10 weeks is about 0.1 to 0.2. In the second trimester, and then again, 8.9, mortality rate of 8.9 per 100,000. Okay, that's approaching, that's in addition to the other complications that occur, such as fever, infection, so on and so forth. And so it probably underestimates abortion mortality. Why? Because women may not die within the first couple of weeks after having an abortion. They may have a prolonged course and die in the hospital or outside the hospital, and the documentation of the cause of death is infection or there's some other cause. However, this study did suggest that there's a 76-fold increase in mortality, again, not morbidity, dying from an abortion between an elective procedure between early and late abortion. Or to look at it another way, for every week, additional week of gestation that an abortion is performed at, the risk of death increases by almost 40% for every week, okay? And of course, this is not true for pregnancy. So when people make this sort of erroneous comparison between pregnancy-related mortality and abortion-related mortality, the risk of death from pregnancy does not increase weekly. It just doesn't. It just doesn't. Keep going. And so, keep going. We talked about this. Keep going. I mentioned this is another study showing the complications of surgical abortion, not mortality, morbidity. So infection rate is almost 20%, okay? Damage to the uterus and cervix is about 2%, and the need for repeat procedure is 0.2 to 2%. But to a surgeon, if you have procedural risks that are greater than about 2 to 5%, that's of concern. Keep going. And that was mentioning medical abortion. So of course, abortion is clearly later. Abortions at later gestational ages is clearly more dangerous. Decreasing late abortions is key to decreasing morbidity and mortality. Keep going. The long-term complications of abortion are quite important, especially as we're considering issues like informed consent and the state's ability to regulate and protect maternal health. In many women who are, especially women in the younger age range, they are infected with sexually transmitted disease such as gonorrhea and chlamydia, and often develop pelvic infections following an abortion. Antibiotics are not routinely given necessarily during abortion procedures. And another complication that I see in practice is chronic pain. And when I have women with chronic pain, one of the questions I ask them is, have you had an abortion? Keep going. And then, of course, pelvic adhesions occur when uterine perforation happens or as a result of infection following abortion. Keep going, keep going. And I was mentioning chronic pain. Okay, keep going. And this is a very interesting study from Scandinavia looking at immediate complications after medical versus surgical termination of pregnancy. Now, when medical abortion or the abortion pill, or various names for it, was introduced, it was seen as kind of the solution to the problem of surgical abortion. In other words, abortion, I think there was a cover story in Time or Newsweek that says, abortion is now truly a matter that's strictly between a woman and her provider. Well, just as a side note, what's very interesting with medical abortion is that with surgical abortion, a woman could look at the experience of abortion and say, yes, someone did this abortion to me. She may have PTSD as a result of, and one thing that women describe with their PTSD is it's activated by things like hearing a vacuum cleaner. That reactivates the experience, okay? With medical abortion, the woman is now the perpetrator of the death of her fetus. And that has an entirely different psychological impact, okay? In addition, for most medical abortions, she completes her abortion at home. And so she actually experiences the process of delivering or of miscarrying, knowing that she was the one that brought it about. Okay, so go ahead. So this is looking at, again, complications, and again, comparing the complications, the risk of complications between medical and surgical abortion. So for example, on the left side, hemorrhage, in the middle, infection. And again, what you can see is that the further gestational age, the further along the gestational age, the more higher likelihood there is of complications, even with medical abortion. Keep going. And this is a direct comparison between medical and surgical abortion of the types of complications that can occur. What you see is that medical abortion is much more likely to cause severe hemorrhage. And again, because when the woman finally aborts, she is at home. She is not in a physician's office. She's not in an emergency room. She's not in a clinic. So keep going. And then another complication that is worth mentioning here, I think, is the fact that induced abortion in a first pregnancy has increased the risk of preterm birth. Now, my college, the American College of OBGYN, will not touch this with a 10-foot pole. They will not touch this. And there's a couple of reasons. One is that they say, well, there's not enough evidence, which is really not true. The second is that abortion is highly profitable. It's highly profitable. I once met a gentleman who was the premier abortionist in Cambridge, Massachusetts, and he was a millionaire several times over, several times over. So yeah, our hands are bloody, okay, our hands are bloody, and I'm ashamed of that, but they really don't want to discuss this. An important sort of sidebar to this is that African-American women are 3 times more likely to undergo abortion than women of European extraction in the United States. The rate of preterm birth is approximately 3 to 5 times higher in African-American women. So, next slide. And this is looking at reproductive outcomes following induced abortion. Again, oh, keep going, this is demographics. I'll go back to the previous slide for 1 sec. And what they're looking at is that if women had an induced abortion, they were much more likely to have a miscarriage. And this Carstairs category is reflecting the fact that in England, you are assigned a social class. It's called the Carstairs categorization. And I believe that 1 is the lowest, this is really terrible, but 1 is the lowest sociodemographic category. And you are more likely to have a miscarriage if you had an abortion. And then these other data are looking at other demographics. Keep going. Keep going. Okay. And I just wanted to briefly mention this. This is another study on induced abortion and preterm birth. Most abortions were still surgical, even in Finland. They had increased odds for very preterm birth. These are the extremely premature kids below 28 weeks in all subgroups. And the risk was approximately 20% higher after 1 abortion, 70% higher after the second, and 278% higher after 3 abortions. And so you also had an increased risk for low birth weight with greater than 3 abortions. Keep going. I want to talk about breast cancer. Now, of course, in pregnancy, breast tissue begins to proliferate in preparation for lactation. The basic science is that the breast cancer risk is increased because this process is interrupted while breast tissue is still in a vulnerable state of development. Keep going. And this association has been suggested since the 1980s. Pike and Howe were some of the early researchers that looked at this. Keep going. And then the Daling study from 1994 kind of put it out there that one of the issues that we were struggling with was that the results are inconsistent. Keep going. Part of this is because breast cancer, and this is John Thorpe from UNC, who is one of my mentors and a dear colleague, says that it remains unclear whether elective abortion increases subsequent breast cancer risk. But it is clear that abortion culminates in a loss of protection, with the net effect being an increased risk. Keep going. So up to this point, I said, all right, we can't really say that abortion causes breast cancer. The association is complex. Why? Breast cancer is really probably not one disease. It's probably several diseases. It's what we, in epidemiology, we call a heterogeneous disease. Keep going. Now, that changed with the publication of this study by Wang et al. In November of last year, where what they found was that induced abortion is significantly associated with an increased risk of breast cancer among Chinese women. Why was this a good study? In China, because of the widespread application of the one-child policy, abortion is very, very common. And the ratio, one of the problems with previous studies is it's hard to sort out whether you were looking at women who had induced abortion or a spontaneous abortion, a miscarriage. Keep going. And so because Chinese women also had low rates of breast cancer, compared with Western women, they began to wonder why over the last 20 years, cancer rates have almost doubled in parallel with the one-child policy, from 36 over 100,000 to 51 over 100,000. Keep going. And so what they found was that with a single induced abortion, there was almost a 50% increase in risk for breast cancer. Keep going. And so that doesn't establish that it causes breast cancer is caused by abortion, but it certainly supports the association. This is, I'm running out of time here, but there's a huge literature on mental health problems. Most recently, Priscilla Coleman did a meta-analysis finding an 81% increase in mental health problems, including depression, anxiety, substance abuse. Keep going. And this is another study from last year which compared outcomes between women who had an abortion, childbirth, miscarriage, or an unplanned pregnancy. And they concluded that fetal loss exposes women to a higher risk for mental health issues than childbearing. Keep going. These are bad slides. Yeah, no, I'm running out of time here. But I did want to mention briefly the globalization of abortion, because Roe really did make it possible. As someone was saying earlier, we were one of the few countries with unrestricted access. Keep going. And I mentioned the one-child policy earlier. Some of you may have seen this slide. This is a young woman who underwent termination of pregnancy, and to humiliate her, they put her fetus next to her in the bed. Keep going. And this is another young woman with a similar situation. This is what happens every day in the United States, every day in China. Keep going. I put this slide up. I know in vitro fertilization is a little bit controversial, but it's one of the few ways that I have to express this wonder and mystery of the joining of they've captured this photograph at the moment that the sperm and egg nuclei are coming together. And one more thing that I'd like to say is that we are now entering a time where we're beginning to be able to treat Down syndrome prenatally. So you can give certain specific proteins that will, as we know, 61 to 93% of Down syndrome fetuses are aborted, specific proteins that will attenuate the effects of Down syndrome. So I think this is a very exciting time. Again, I think that the strategy of looking at abortion, having two victims, is a very important one. And I do feel that as obstetricians and people who are scientific, providing scientific advocacy, this is an area where we can make a huge difference. So, thank you.
Well, I know I'm grateful, and I'm sure I speak for everyone, to have had those presentations about how we can reverse Roe from the medical and the political and the legal vantage points. We have a couple of minutes for some questions. So does anybody have any questions for our panelists who are left? Yes?
I'd like you to all comment on the possibility of doing civil class action suits. Oh, I'm sorry. I'd like you to comment on civil class action suits. Our district attorney here gave us an excellent overview of an attorney general's duty with regard to statutes. But we have women, granted that it's difficult to get them to bring evidence to court of how they were injured in the clinics. But I think this is something we need to think about and try to push for. This is how we got Roe v. Wade, maybe this is how we could eliminate it. The second, a corollary of that would be, has anybody thought about having aborted mothers bring a suit on behalf of their viable fetus in cases where the aborted mother didn't have sufficient informed consent? And now you have a viable, or in some states maybe even a non-viable fetus. The estate of the viable fetus might bring suit, wrongful death actions.
Okay, thank you for your question. Carter, do you want to address that?
Yeah, I'll take a cut at addressing those interesting and thoughtful questions. First of all, I'd like to say, though, that anybody who's interested in learning more about the science, theology, law, public policy, or communication strategies, or the politics of the right to life issues should feel free to come to my center. You can come to Notre Dame for a week to the VITA Institute. The Center for Ethics and Culture, which I direct, sponsors a week-long interdisciplinary seminar for the leaders and emerging leaders of the pro-life movement. And Catherine has attended some of those sessions, and we think it's a great opportunity to go in depth on these questions to make excellent pro-life advocates even sharper and more effective. So back to your question, I'm very much in favor of harnessing the creativity and energy and aggressiveness of the plaintiff's injury bar. Rhetorically and politically, we've created this narrative about big tobacco, big oil. I think big abortion is something that would have a lot of traction in the public square, and the idea of suing these folks and demonstrating how irresponsible they are, how negligent they are, in some cases how criminal they are, and that's important for attorneys general to be involved as well. So I think the class action lawsuits are interesting. Obviously, the problem of identifying the women who are willing to come forward might be an issue, but there's a huge array of unbelievably brave women post-abortive women who come forward. The Silent No More campaign. I mean, I'm sure that there would be a lot of opportunities for collaboration. I understand that there have been some lawsuits pursuing the informed consent angle that you have sketched out. There are some procedural complexities with that. I'm not sure. I know Sam and others, I think, have been involved. Sam Casey has been involved in pursuing these cases. Some folks in New Jersey have as well. And so that's an interesting, there's a lot been written about that. But my bottom line is I think it's absolutely imperative to pursue on all fronts, litigation, public policy, rhetoric, everything, to do everything we can to try to combat this. And at the very least, I mean, I'm amazed, well, there was a total media blackout on the Gonzales case, but you would think that that would be a moment where people's attention would be drawn to the real ugliness of what abortion looks like and the people who are doing it.
And also on the Gonzales point, the Attorney General was talking about how did that woman get there? I mean, to be in that situation where you're so desperate that you wind up in that house of horrors, as Anna described it. I mean, we have a duty to make sure women don't wind up at places like that, and places like that can be your pristine abortion clinic as well.
Yeah, I think it's a very. Is this one? Yeah. I have a big mouth. I think that the issue of women, you said something very, I think, significant. Why would someone go to a place that was obviously just a horrible place? And the reason is that I think in talking to women who have been through abortion is number one, shame. Okay, number one, desperation. This person Gonzales advertised that he was able to do the later procedures, and there really aren't a lot of places, thank God, and actually fewer and fewer places. And this is actually something that should encourage people. The number of residents who choose to learn abortion is declining every year. Partly that's because the Gen Yers and the millennials are the most pro-life generation. I mean, like, my kids are crazy pro-life. I mean, so
you'll see some of that in a few hours.
So I think that there's just a sense of shame, there's a sense of desperation. That to me is the ultimate victimization. where a woman feels that she has no other choice for economic reasons, because she's her pimp, her trafficker, her molester, her abuser, whatever, brings her in and says, you have to do this, okay, you have to do this. And so I think it's very, 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 very difficult for women to come forward and allow themselves to be put in a position where they're going to be in any kind of a public spotlight. That's really hard. They'll fill out a questionnaire that they'll talk about, women will talk about their experiences. In my clinic, they'll talk about what abortion was like and how it affected them. But as far as coming into the public eye, that's really hard. That's really hard. I think it's harder for them in some ways than even for rape victims, because for rape victims, they are looking at, okay, there's a legal issue here. And again, as someone, I testify in rape cases because they come to see me in the ER afterwards. I want to pursue justice, okay? But what do you say? I got an abortion. Is that a good thing somehow? I was raped, but that wasn't my fault. I made a choice to have an abortion. So it's a difficult, it's very difficult. And it is a victimization in a very profound way.
Do we have time for one more question?
This being a new frontier panel, what's the abortion industry's new frontier? If I was going to their new frontier conference, what would they be saying? And I think one of the things that I direct this question to Dr. Sherrill, they'd be saying, we don't need docs.
Yeah.
We never needed docs. We can do this ourselves. And we can certainly do it with the pill. As we address their new frontier, what is our response?
Yeah, that's a good question, and I always have way too many slides in my talk, so we didn't get to that part. But I think there's two answers. One is I was going to bring up the issue, and I really thank you for doing that. I was going to bring up the issue because fewer and fewer physicians are performing abortions at all, and because the only people who know how to do the late-term abortions are all, old-timers. Okay, we are taught in OB/GYN residencies, if you have a woman who has a demise in the mid-trimester, how to complete those. And actually, misoprostol has been a huge help for that. But the actual termination of a living fetus, which often involves injecting potassium into the heart with amniocentesis and ultrasound to stop the heart, to transect the cord, those are skills that are less and less offered, and very few people are looking at those. So they have to have non-physicians doing even early abortions. That there's an excellent website called APNC, I believe, and I can look it up on my talk, that tells mid-level providers, nurse practitioners, midwives, and physician assistants how to skirt state legislation in order for them to be able to perform medical abortions and to some extent early surgical abortions in their offices. That's because they recognize that organizations like American Association of Pro-Life OB/GYNs, which I'm a member of, we're constantly kind of trying to work with physicians. We have not really looked at working with the nurse practitioners and so on and so forth. So that's a huge issue, but that is an issue that I think is easily resolvable through legislative means at the state level. You just have to be aware that that's something that's going on, that there's a very strong push for both medical and surgical abortion to be done by mid-level practitioners instead of physicians. I think the second issue, as far as frontiers, we are now at a point where we're able to diagnose. Usually if you wanted to diagnose Down syndrome, you had to do it relatively later in the pregnancy. That's being pushed back earlier and earlier. We can diagnose many issues earlier in pregnancy with what are called pre-implantation genetic diagnoses, especially in women who have had in vitro pregnancies, and that's routinely offered. Women who are having in vitro pregnancy, they say, well, we'll do a certain number of embryos, and we'll take one embryo, and we'll test that embryo to see if that embryo has this particular genetic mutation, whatever, so you don't have to have a defective embryo implanted. So that's kind of where the Brave New World type of thing is going with this. And there's actually a recognition that as our ability to detect more and more genetic abnormalities, and the way this is done is that fetal cells are floating in maternal circulation during pregnancy. So bits of placenta and fetal DNA are present in maternal blood, and so when you draw a woman's blood, you can extract that DNA and look for known genetic mutations. And then if you find them, offer that woman and say, well, you know, we found this abnormality and you should terminate your pregnancy. So that's kind of where it's going.
I mean, we would be kidding ourselves if we didn't think that there was a well-organized, well-funded strategy to do exactly what Sam implies in his question. You've seen this in California. They passed a law that allows non-physicians to perform abortions. This is part of a legal strategy. You have, unfortunately, professional societies like the American College of Obstetricians and Gynecologists who are agitating to make abortion the standard of care for certain kinds of circumstances, telemed abortions. These are all laws and of course RU486 to try to take abortion out of the clinic and into people's homes. And this is an area where we have to be prepared and have a robust legislative strategy to either preempt these things or not. And they bump right up against our concerns about conscience and religious liberty, because the less abortionists there are, the more folks of good conscience are going to be forced, or they're going to try legally to force people to either perform abortions or refer for abortions. And just the last thing I'd like to say is I didn't see Harold Cassidy sitting over here at the beginning. He is one of the pioneers of helping women who have been harmed by abortion in terms of get relief in court. And so I wanted to recognize him.
And to circle back to New York State, that's what California just did to expand access is exactly the reason Andrew Cuomo wants pro-lifers to shut up in New York, because he's looking to do something similar in a state that has some of the highest abortion rates in the country. Thank you again to Carter and to Dr. Scheru and the Attorney General. And Americans United for Life, and a great civil servant is going to wrap us up.
Well, good morning. My name is Ovid Lamontagne. I'm General Counsel for Americans United for Life. I hail from New Hampshire, and the snow does not deter me, and it apparently doesn't deter you either. Thank you for being here this morning. And what a great panel we've had, huh? Why don't you give them another wonderful round of applause. Some of the takeaways I say is just simply this. When it comes to the law, as Professor Carter Snead has explained, there's room to move. We should continue to debunk the myth that in America, abortion on demand is what the law is. It is not the case at all. And what's really important about his presentation is that the law says that there are two victims of abortion, and that the state has a legitimate interest in protecting the unborn child and the mother. And we need to merge those interests together in our strategy going forward, because indeed, being pro-life, vindicating life means vindicating women as well. And that's what the law provides. And Dr. Monique Scheru made it very clear that the facts are on our side. Thank you for your presentation, which gives us the facts, the evidence to go forward in the halls of our legislature and courtrooms of our country to make the case, applying the law to the facts as we're required to do in courts. The Attorney General of Oklahoma, Scott Pruitt, was quite compelling, and letting us know that we need to make sure our legislation is founded in sound evidence, and also that our litigation conducted is founded and defended with that sound evidence. And he also made a very important point. Do not lose heart. Do not despair. Do not be discouraged, for indeed, discouragement and despair and losing heart is a sin against God, and it's a sin against each other. We cannot give up this fight. And for the lay people in our audience, I think the Attorney General also said something very compelling. You matter every day that you're out there fighting for life, fighting to protect women, bringing forward testimony at the hearings, contacting your legislatures, getting involved in elections to make sure the people who are elected truly walk the walk, not only talk the talk.